Breaking news. The Cabinet inquiry has found that there was no credible evidence presented that Advocate Andrew Chauke was not fit to hold his office and has cleared him of all charges. President Cyril Ramaphosa has addressed a letter to Advocate Chauke informing him of this, and that he is fit to continue with his duties. The inquiry has also found that there is basis and evidence that charges should be instituted against General Major Boysen and the Kator Manor Unit. Retired Constitutional Court Justice Bates Elizabeth Nkaband on Wednesday, July 1, 2026, presented to President Cyril Ramaphosa the report of the inquiry into the fitness to hold office of South Gauteng Director of Public Prosecutions Advocate Andrew Chauke. President Ramaphosa established the inquiry on September 29, 2025 in terms of Section 12(6)(a) of the National Prosecuting Authority Act 32 of 1998. The mandate of the inquiry was to investigate and determine whether Adv Chauke was fit and proper to continue to hold such office in the context of certain serious allegations regarding his fitness and propriety to hold such office. Its terms of reference were in line with the requirements of the National Prosecuting Authority Act, read with Section 179(3) of the Constitution. President Ramaphosa placed Adv Chauke on suspension with effect from July 20, 2025. Pending finalization of the inquiry. Today, President Ramaphosa expressed his appreciation to Inquiry Chairperson Justice Nkaband, assisted by Adv Elizabeth Baloyi Emir SC and Attorney Matshego Ramagaga, for the work undertaken by the panel. President Ramaphosa will now study the report and subsequently make a determination. Just want to remind you what happened at the Commission when former National Director of Public Prosecution Advocate Batohi was being cross-examined.
Advocate Riley, can I just ask you to start with, this is a disciplinary inquiry against Advocate Chauke, and the allegations which you said you were familiar with are that he supported or endorsed or promoted a decision to charge Major General Boysen and others with racketeering despite no evidence. Correct? You are familiar with that?
That is correct, yes.
Yes. And one of the, in fact, the only ground upon which he has been charged in relation to the Kator Manor issue is your report, correct?
If I read the charges, that is correct, yes.
Yes. Did you recommend that he should be charged with misconduct?
No.
Yes. And so that was a decision of the NDPP, not your decision?
I wasn't involved in that decision.
Yes. Now...
I beg your pardon? What's the answer?
Says, well, can you repeat your answer, Advocate Riley?
I wasn't involved in that decision.
And your recommendation is made a decision. That decision is then set aside by the High Court. On the logic of Advocate Batohi, you would be guilty of misconduct.
I'm not guilty of misconduct. I disagree with you.
No,
I was part of a panel of 4 people. We were requested to review the evidence, which we did, and we made recommendations to the NDPP.
I understand.
We did not tell her to follow those recommendations.
I understand precisely. That's exactly what happened to Advocate Chauke. He was not a decision maker. The decision maker was the NDPP. He is charged for recommending and supporting, which is precisely what you have done. And he is also charged because he comes from Gauteng and is involved in matters from KwaZulu-Natal. You come from Cape Town, you are involved in a matter in KwaZulu-Natal. So it seems to me that it's hypocritical for you to say, no, you should not be charged, but Advocate Chauke should be charged.
I didn't institute any charges against Advocate Chauke. I never said he should be charged. You are there, you are incorrect.
I see. So you would agree then that it would be wrong to charge Advocate Chauke merely for making a recommendation which is not binding on the NDPP?
I did not make the decision. Neither do I know on what basis that decision was made.
I understand that, but if you want us to go through the terms of reference, we can do that. It's clear on what basis the decision was made. I'm simply testing whether there is consistency inside the NDPP's office. That's why I'm asking you that you cannot be a hypocrite. It is either you agree with me that if the MK party succeeds, you should also be charged with misconduct, or you say, I don't agree with you, in which event that applies to you and it applies to Advocate Chauke. It's as simple as that.
It's not as simple as that. Like I said, in our line of work, we make decisions every day. We also ask for opinions, and this was exactly what has transpired, to make a decision on recommendations to the NDPP. She wasn't bound by our recommendations. She says it in her internal memorandum to us that the final decision will lie with her.
Yes, but
in respect of the charges, I was, like I said, right, in respect of your first question, I was not involved in any way with the decision to charge Advocate Chauke.
Yes, but I'm asking you for your opinion now. I hear what you're saying. Whether or not the DPP of South Gauteng, who is in the exact same position as you, was correctly charged for making a recommendation that is not binding on the NDPP. What's difficult in committing an answer to that?
Because I was not involved in that decision. I don't know on what basis the decision was made to charge him.
All right, well,
if you can explain to me that, then that's fine. But right. I wasn't involved in that decision.
Okay, let's look at the basis for it. I'm going to ask you to look at the terms of reference, which set out the basis. I've got Sidiso, I need my copy of the terms of reference. Oh, I don't have the... Are you able to find it, Advocate Riley?
Can you refer me to where I can find it? Then I can ask Advocate Legeto to assist me.
I'm sure she can find it. She knows her way around the papers. It's in various parts.
I do have it now.
Thank you. If you can turn to page number 6, paragraph 3.1.1.1. Can you see that?
That is correct, yes.
Yes. Now, the opening paragraph there talks about racketeering certificates, correct?
That is correct, yes.
And it's common cause that racketeering certificates are within the exclusive jurisdiction of the National Director of Public Prosecutions, correct?
That is correct, yes.
Now, 3.1.1.1 accuses Advocate Chauke of supporting a decision, not making it, supporting a decision to charge Major General Boysen, correct?
That is what it says, yes.
You would agree that he's not a decision maker, someone else is a decision maker, correct?
That is what it said, supported a decision.
All right. If you then go to 3.1.1.2, it talks about recommended, correct?
That is correct, yes.
And again, even there, he's not the decision maker, he's merely recommending, correct?
That is correct, yes.
Now, that is what I mean when I say he is in exactly the same position as yourself, where you are either supporting or recommending a particular decision, but it is not your decision, it is the NDPP's decision. So
That is correct.
this is the basis of the charge that you are looking for. Now, I come back to my original question. If you say, if this decision is subsequently set aside of Advocate Batohi, you should not be charged for supporting or recommending. You must agree that even Advocate Chauke should not be charged for supporting and recommending.
I didn't draft these charges.
I know you didn't, and I am asking you deliberately because you are in exactly the same position as Advocate Chauke, that it seems to me it's logical, unless you want to be hypocritical, that if you say you should not be charged for supporting and recommending, it must apply to Advocate Chauke. What's difficult in saying what's good for you is good for him?
Are you able to comment, Advocate Riley?
I'm not able to comment because I was not part of this decision making. To charge Advocate Chauke, I don't know the basis for it, and I didn't draft any of these charges against him.
So your answer is, should we understand your answer to be no?
That is correct, yes. I did not, I was not involved in this decision to charge Advocate Chauke.
No, that's not the point. The point is not whether you were involved or not. The point made by counsel is that if you are similarly placed as Advocate Chauke, or in the position similar to Advocate Chauke, because in your report, together with your colleagues, you supported and made recommendations in relation to racketeering authorizations to someone, well, let me put it directly, to Advocate Batohi, who has the power to decide on those racketeering authorizations. She has exclusive powers to decide on these racketeering authorizations, not you, not Advocate Chauke. And counsel is saying, because you are in the same position, doesn't it then follows that if Advocate Chauke, who is in the same position as you, who is alleged to have done what you did in your report, should then make you to be in the same position, and therefore you should also be subjected to the disciplinary hearing? Because you supported and recommended on the decision on the matter that falls within the exclusive powers of the NDPP.
And you come from Cape Town.
And yet you come from Cape Town.
Once again says, I do understand we gave an opinion. We also made certain recommendations in respect of whether the application for racketeering authorization by Advocate Abrams is valid or not. Like I said, in terms of 3111 and 3112, I do not know the basis on which they are saying what is the evidence or information that they have where they said he supported a decision. I can speak to what we did in terms of our recommendations, but I cannot speak to what is in 3111 and 3112 as to why those charges were put.
No, Advocate Riley, it's very simple. I can tell you, it's very simple. They are saying Advocate Chauke is from Johannesburg. He's getting himself involved in matters that are in KZN. And he is exceeding the scope of his jurisdiction. He's violating the law. That's what they're saying. Advocate Batohi said this many times. I look at this report you've prepared. I see that the other two gentlemen are deceased. The two that remain is yourself and Advocate Tenga. Unfortunately, you are the only one who's testified here. That's why I'm putting to you that if it is misconduct to make a recommendation on a matter from KZN that falls within the exclusive power of the NDPP for Advocate Chauke, it is also misconduct to you. Should you now also receive your charge sheet? That's the simple question.
You indicated, and that's what I'm trying to indicate, what the evidence, on what basis they are saying he supported a decision in his capacity as the DPP. You now mentioned the fact is because he was the DPP in South Gauteng and he tried to improperly have the acting director of public prosecutions, KZN, sign the case dockets or a prosecution memorandum. That's the basis. That's not an opinion. That's not an opinion. And I keep on saying, we were asked to provide an opinion and recommendations. That charge is different. And on what basis and what evidence they have to support that charge, I am not privy to it.
All right. So you would say the mere fact that he provided an opinion or supported a decision or made a recommendation on a matter that is from KZN, the so-called exceeding the jurisdiction charge, you would agree with that or not agree with that? I just want to get a clear answer because it seems to me you are similarly placed.
I'm not similarly placed.
All right.
As I indicated, the allegation against him that he sought to improperly have the acting director of public prosecution, KZN, sign the case dockets and or prosecution memorandum, I cannot speak to that. But that's very different from granting an opinion, reading dockets and giving an opinion to the NDPP.
Yes, I see. So if it was only about Boysen, should not have faced the murder charge.
Not at all.
So you accept that he should have continued to face the murder charge or not?
Can I answer that question?
Yes.
After I decided to withdraw the racketeering charges, I sent all of the dockets back to the DPP KZN and asked her to consider each one of them and whether anyone should be charged with the predicate offenses outside of racketeering.
No, I still don't understand that. I'm asking you about the charge against Advocate Chauke. Whether or not you accept that there was sufficient evidence for Major General Boysen to be charged with the crime of murder or not? Or do you say there was also no sufficient evidence of the crime of murder?
On the basis of the decisions of the DPP KZN, after I sent the dockets there, she found that there was no evidence to justify murder charges against any one of the accused, except in the one docket. And that did not include Major General Boysen.
Yes. Those are later decisions. I'm asking you about the decisions taken by Advocate Chauke. Is it the case of the NPA that Advocate Chauke erred in charging Major General Boysen with murder?
My understanding is that Major General Boysen was charged with racketeering and that those were the predicate offenses.
Yes.
And that is where we say Advocate Chauke erred in supporting racketeering charges.
Yes.
I beg your pardon, Advocate Batohi. Is this question premised on the assumption that Advocate Chauke made a prosecutorial decision to charge?
Yes, I'm working now on the best case for the NPA.
That's why I'm asking the
Yes,
question,
no,
because all along, when we read the opening address, it seems to me that there was an issue regarding whether he made a prosecutorial decision
Yes.
in relation to the Katomena matter. My understanding of the evidence favorable to you was that Advocate Chauke was appointed merely as a coordinator in relation to the KZN Katomena matters.
Yes.
That's why I'm asking the question as to whether you premise this question on the assumption, at least for now,
Yes.
that he did
Yes.
make this particular
Yes.
prosecutorial decision
Yes.
as regards the charge of murder against Major General Boyson.
Indeed. I'm working now, Madam Chair, on the best case for the NPA, that Mr. Chauke has taken all of the decisions they claim. I'm trying to understand the substance of the complaint, but I will still deal with whether he did make those decisions or not. So I'm still trying to analyze the charge. Let's come back then, Advocate Batohi, to understand what 3.1.1 is about. You have said that your understanding is that murder featured only because it was a predicate offense, not because it was an independent offense. Is that correct?
It was a predicate offense to racketeering, that's correct.
Yes. And therefore, it is irrelevant to Section 2, subsection 4 as an independent offense. It is only relevant as a predicate offense.
That is correct.
Yes. All right. Now, the reason I'm asking you this is because even on your own version, you've accepted that at least in relation to one of the charges, there was sufficient evidence to prosecute. Is that correct?
No, I'm not understanding you.
Well, you've told us that you gave all of the dockets to the DPP of KZN. She enrolled one case against Mr. Padiache on a count of murder. So she must have considered that there was sufficient evidence to charge Mr. Padiache with murder.
Yes, I didn't realize you were referring to that docket. That's correct.
Yes. So that's why I come back to say, in at least one of the cases, there was sufficient evidence to proceed with the murder charge.
That's correct.
Yes. Now, that distinction is not made clear at all in 3.1.1. If you read 3.1.1, it suggests that in none of those cases, there should have been a charge.
Against Major General Boyson. That's what that suggests.
No, that is false. It says Major General Boyson and members of the Katomena unit.
Let me read this carefully.
Mr. Padayache was a member of the Katomena unit.
The point I made earlier is that this related to racketeering charges. And therefore, it's clear here that this section is relating to racketeering charges and murder as a predicate offense and not as separate independent charges. And so it's correct in that regard that it is racketeering. It doesn't refer to murder at all.
Yes, I thought we had moved from that question and we were debating the independent charges. And I asked you a question, whether you would accept that in at least one of the dockets, the case against Mr. Padiache, there was sufficient evidence to charge, and I understood your answer to be yes.
That was my answer.
Yes. And when I proceeded with that, you said, well, exclude Major General Boyson. And then I pointed to you that actually exclude all members of the Ketumano unit.
The point I make is that whether it's Major General Boyson or all members, this particular paragraph refers to racketeering charges and not independent murder charges.
Yes. Now, could I then ask you to turn over the page? 3.1.1.1 refers to supporting a decision to prosecute the accused. Who is the accused?
All the accused in the racketeering charges.
Yes, that's where we come back from, where you say no evidence justifying the decision. And now we understand that you would accept in relation to one, that there was evidence justifying a murder charge against Mr. Padiache.
But not a racketeering charge.
Yes, I understand.
Anyone.
You've made that clear. I'm asking you a different question. Was there sufficient evidence, in your opinion, having studied the dockets, if you did, to support a murder charge against Major General Boyson?
There wasn't.
There wasn't. Now, you gave evidence earlier that you did not study the dockets and you relied on a memorandum by Advocate de Kock. Was that evidence accurate?
That's correct, but my answer now also relies on the evidence of a report of the DPP KZN.
Yes. I'm not asking you about the DPP KZN. I'm asking you, at the time you took the decision to institute a disciplinary case against Advocate Chauke, you relied on the report of Advocate de Kock. You never studied the docket. Is that not correct?
That's correct. I didn't, let me just check the time that I decided. No, that's correct. I didn't study the dockets, the 23 dockets.
Yes, I'm asking just the docket around Major General Boyson. 2 murder charges, 1 charge of defeating the ends of justice, 2 charges of violating the Firearms Control Act. Can I tell you, Advocate Chauke read the docket. Did you know that?
I would have expected him to.
Yes. But you have come to say to the panel, there was no case against Major General Boyson without ever having read the docket. Can I suggest that that is an astonishing proposition coming from the head of our prosecution service? And I'm going to tell the panel that at the end, that your evidence must be rejected as incredible because it is irresponsible to make such a claim without having read the docket.
It's not irresponsible at all, and I'll explain why. There's case law that national directors are not expected to read every single bit of evidence and every docket in cases, and that they are, it's perfectly acceptable for a national director to rely on reports, to rely on presentations, to request aspects of evidence, and to take decisions on that basis. So it's certainly not irresponsible. It is what is expected of a responsible national director.
Yes. But can I also suggest something else to you? That Section 2 of the Prevention of Organized Crime Act is within the exclusive power of the NDPP. Do you accept that?
I'm not sure what you mean by exclusive power, but
Well,
certainly
only the NDPP can sign a racketeering certificate under Section 2, subsection 4. I would have thought that to be obvious.
certainly I agree that only the national director can sign that authorization.
and exclusively the NDPP. No one else can sign a racketeering certificate.
That's correct.
Yes. Now, it's in that context that I say, for you to tell the panel that there is no case against Major General Boyson, also of racketeering, without ever having studied the docket against him, is a grossly irresponsible thing.
I repeat what I said.
Of course.
There's case law that states that a national director is not expected to read every docket and to look at every piece of evidence before coming to that conclusion. A national director, it's permissible for a national director to consider evidence that is presented to him or her by a team, presentations, and to ask for specific aspects of evidence if he or she requires it. But it's certainly not expected of a national director to read every single docket in any context. Sometimes a docket can fill a room, and it's certainly not expected that that is what a national director should do.
Well, can I challenge you on that and put two propositions to you? Firstly, the docket against Major General Boyson does not fill a room. It's a small docket. Do you accept that?
I'm not sure that there is a docket against Major General Boyson. I know that there were 23 murder and other related charges, dockets. I'm not sure that there ever was a racketeering docket as such.
Now, you see, the problem is that you answer, but you always overlook what you wrote. Go to 3.1.1.1, where you say, supported a decision to prosecute. I mean, I know you say it's the president who says this, but you never wrote this, or you don't know the difference, so I will accept that until I see what you wrote. Your answer remains qualified. Mm-hmm. That there was no evidence justifying the decision, and that he sought to improperly have the acting director of public prosecutions of KwaZulu-Natal sign the case dockets. You are the one who relied on case dockets. Now you are telling the panel there was no docket.
I said there was dockets. There were dockets, lots of dockets, but I'm not aware of a racketeering docket as such.
No, Advocate Batohi, I think there is a real problem. You have said that 3.1.1 is exclusively about racketeering and does not include the independent offenses. And you have also confirmed in 3.1.1.1 that that too is exclusively about racketeering. The charge refers to case dockets. What case dockets are those?
Which charge refers to case dockets?
Read 3.1.1.1.
Yes, it does appear there.
It was put there by you.
I'm not sure about that. We'll have to check that.
Yes, but then answer my question, please. The docket that is referenced, we have gone through this exercise ourselves. It is only 7 charges against Major General Boyson. Mm-hmm. It is not the exaggerated docket that fills a room. What do you say to that?
The only point I made about dockets that fill a room is to make the point that it is not expected of a national director to read every bit of evidence when a decision is made. That's the only reason why I mentioned that. But getting back to this issue, there were dockets relating to, there were the 23 case dockets. I'm not aware. Let me read this carefully before I answer this. This is clearly incorrect, because to say that he sought to improperly have the acting director of public prosecutions of KwaZulu-Natal sign the case dockets it's not our case that Advocate Chauke asked the DPP to sign any case dockets. So this is clearly incorrect. And
so the charge is incorrect.
If I may be allowed to complete.
Yeah, all right, sorry, I thought you had finished. Please continue.
Okay, and or the prosecution memo. He sought to improperly have the acting sign the case dockets and or sign the prosecuting memo. If you read it like that, it's incorrect. That is not what we're saying.
So charge 3.1.1.1 is a wrong charge.
It's incorrect.
Well, incorrect and being wrong are the same thing.
Well, part of it is correct, is that Advocate Chauke supported a decision to prosecute the accused, notwithstanding that there was no decision, justifying no evidence, justifying the decision. And then the next part of it is incorrect to the extent that I've indicated.
You see, that's why I need the memorandum you gave the president to see whether the president is at fault for charging Mr. Chauke incorrectly, or whether you are at fault but are now escaping responsibility.
I'm trying to explain as best I can and not to escape responsibility.
Yes, no, I understand that. I'm not criticizing you, I'm criticizing your evidence.
That's fine.
Now,
Before you proceed, I think this will also help us, Advocate Batohi. When you look at the gazetted terms of reference, the date is the 30th of September, 2025.
I don't have that gazetted copy in front of me.
The front page
Oh,
of
there you
the
go.
Gazette.
I have it now. Yes, that's
Regulation
correct.
Gazette number 11889, volume 723, 30 September 2025, number 53444. You
That's
have
correct.
that. When did you see for the first time the gazetted terms of reference?
I'm not sure, Chairperson. I can't recall when I saw it for the first time.